Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. So I need some veterans to know that if you've succeeded in your VA claim, you can be 100% P&T, whatever the case may be. And I know that was probably, potentially quite an endeavor. I've heard it can be really, quite a exercise in patience and frustration and time and all of that stuff. So, I've seen the question where, I'm getting a function report from the SSA because now that I'm doing an SSD claim, and I've already given this kind of information to the VA. Can't they just go look at my file? That is not going to happen. Yes, they will get your file, but the questions with VA are not going to be the same as the function report. And the laws surrounding what those questions mean, depending on how you answer it, is also going to be different because, as you probably know, oops, the level of disability for SSD, for Social Security Disability, or SSI, but usually in this kind of case with the veterans, we're talking about SSD, right? The level of disability is really far more arduous under SSD than under the VA. I would say it's a general rule, particularly because most of the time there is no restriction where you have to prove you can't do any job, and you don't under VA. I mean, I know there's some exceptions, but and under SSD, it really is you can't work full-time at any job within their rules. And the function report, like, again, I don't know that I've ever seen any kind of function report in a VA file. Not that I look at a lot of VA files per se. I don't handle them. I just use the medical that we're allowed to use for the VA. Now, any statement you made, of course, could be used to reflect your status or your statements about your condition or your symptoms and limitations at the time you made them to the VA, for sure. And that can be helpful because it's historical. You didn't make it up now. And look at 2 years ago, you were saying the same thing, even though your case for SSD might have just started now. So that can be helpful in that regard, but that's not the same function report. That's going to be, function report is very specific. So you definitely cannot get away with not doing it just because you feel like you've answered those questions to the VA. You're answering it to the SSA now. Totally different ball game. And secondly, and this would apply to people who have done a function report and now 8 months later they have to do another one. They're like, I already did one. I'm like, yeah, that addressed your situation then. Because remember, it says, tell us about your situation now. 8 months later, people, by and large, have a different situation. A lot of times the pain is worse, the limitations are more, maybe they rest more. So no matter what you said back in the day, a year ago to your VA doctor, or 2 years ago, or on any kind of form or questionnaire, it's presumably could very easily have changed. And honestly, particularly with SSD, I generally want to interrogate my people and be like, come on, something must be, you just said no change. What is the chances that your body has not changed in some way in this 18 months since you last, whatever. And I mean, they even sometimes have new impairments and they're still saying nothing's changed. So, people just aren't thinking it through and really taking the time to think through the question and dig deep. So a new function report is about the current time, not the one you did, not a time period a year ago when you did it before. So anyway, I hope that clears that up. You have to do all the reports that the SSA asks for. You just do. And it's to your benefit. And as a lot of veterans know that have gotten denied in the SSA process. It's a whole different animal. The definition of being disabled is different, in my opinion, is usually, by and large, much more vigorous a standard, higher threshold of disability. The difference is it doesn't have to be service connected, right? You don't have to have a service connected anything to get SSD. They don't care what caused the problem. They care if you are disabled or not. So it's what your functional limitations are now, today, and at any time that you are claiming that you are disabled under the SS rules. Okay. So anyway, get that function report done. And if you don't have a representative, you probably should consider getting one. So you're not, I think you just decrease your chances of not prevailing. Obviously, you don't eliminate them because there's too many wild cards, but the chance of prevailing earlier, and in fact, I just got notice of a win on initial, so I'm thrilled. And I messaged my guy, and I'm not sure if he's going to get it anytime soon because I think he might be indisposed at the moment, but hopefully he will. And yeah, so not to tout the horn of representatives, but if you have one that does this a lot, has been doing it a while, and does it exclusively, and you're not like the redheaded stepchild of a case because it's SSD when they have, a $250,000 personal injury case out there, you probably don't want those guys, in my opinion. Get some help. Make sure your answers, and I would say definitely for the work history report as well. That one is particularly for the over 50 crowd, critical, critical, critical. It's very critical that you be very precise. And there are things that I see it all the time, people leave out because they're not thinking about that when they're thinking about their job duties. But it's stuff they did. And it can be a clincher. So, all right. I'll talk to you guys later. Have a good one. Bye. Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Good morning. Really super quick one here. This is about the confusion some veterans have when they have 100% or nearly 100% VA disability compensation, and they think it means it's a shoo-in for Social Security disability. Unfortunately, it's not. It seems like it used to be a little bit more of a weight-carrying finding when it came from the VA, but it seems that of the last 10 years or so, maybe, in what I've seen, it's not so much. The main reason, though, is that VA disability is different than Social Security. The definitions of what makes you eligible for financial benefits is very different. For instance, Social Security insurance is actually to replace what you're not, a portion of what you're not able to earn because you become disabled, and it's insurance that you paid for specifically over the years that you were working. The VA disability is a compensation for you having gotten injured during service. So it's to compensate you. It's not an insurance. It's really to make up for what was taken from you by the service, in a sense. So that's one major difference. The other one is VA disability goes by ratings, and I am not a VA disability attorney. I contemplated it, but I spent so much time staying at the top of my game with Social Security, I didn't think I would be able to do the kind of job that our veterans deserve. So I defer to my veteran disability colleagues. So the VA disability goes by the ratings. I think you're all probably familiar with that. And you don't have to be fully unable to work any job to prevail and get compensation for what you have lost due to your service. On the other hand, Social Security disability is a program where it's all or nothing. You're either found to be unable to in a nutshell, perform any full-time occupation on a sustained basis that exists in substantial numbers in the economy, or you're not. It doesn't mean you have to be an invalid or bedridden all the time, but an 8-hour full-time job has to be off the table. And it's a pretty nitpicky process to prove that all approximately 12,000 occupations are unavailable to you on a full-time basis. So all or nothing on Social Security disability, not all or nothing with VA disability. Of course, with VA disability, you have to prove the service connection of your impairment. With Social Security, you do not have to prove how it happened, why it happened. It doesn't have to be caused by anything specifically. In this way, it's different from VA disability or workers' compensation, which has to be work-related. So those are just a couple of the differences. Again, all or nothing with Social Security disability. You have to be unable to do all full-time occupations, as the term of art goes. Unlike VA disability. And that's where the confusion, I think, comes in, because people often assume that if they're disabled as a veteran, they're going to automatically be disabled under Social Security disability. And that's just not the case. That said, if you believe you can't work full-time at any job, even if you can work part-time, which is fine, don't hesitate to file for Social Security disability if you are VA disabled, because there is a good chance you might meet both criteria and you will have so much more income than just the one. The Social Security disability income may not be super high, but everything added to your well-being and your financial security there at home is always a plus. So don't hesitate. It doesn't cost you anything to file. It doesn't cost you anything generally to get an attorney either to do the legal part of it for you. So don't hesitate. And if you have any questions, you know where to reach me. Have a great day.